would like to thank you, the organization, the IIPLA, and all of you. Welcome again. Is it open? Yeah. It's okay. Okay. I would like to give you brief and general strategies about the IP management strategies and the approaches, how it will be. The main, when beginning the IP management, I would like to give you the 4 main pillars of management. It's the creation, the IP, evaluation, protection, and the exploitation part. And in the creating and evaluating part, it's the important to awareness the creation and the teaching and training, especially the R&D people. Especially if you are in in-house counsel, it's very important. And then while evaluating, then you decided to have the IPR support, like patents, designs, or copyrights. You have to decide it. And of course, for the motivation of the inventors especially, you should give innovation awards to provide the continuous projects. And for the exploitation part, the business strategies are very important. I'm giving only the titles because we will talk in deeply in the next slides. And license agreements, spin-outs, and the assignments and sales part is important for the commercialization of the IP also. And when we look at the tools and processes using this, the confidentiality is very important, especially if you are working with third parties. And I'm from pharmaceutical company, so in my case, it's very important because you have projects with you can have for universities, for example. And you should use the non-disclosure agreement. And for capturing the information, it's important to use the lab notebooks, work journals, design mock-ups, or storyboards. We will have, at the end of the slide, there's a case that I would like to show you, and it shows how important to keep the lab notebooks for the pharmaceutical inventions especially. It should be important for the IT and mechanic probably. And of course, for the reporting to invention, the invention disclosure form, it's very basic, but it really helps to determine the inventorship and the ownership. And at last, the protection, as I told you before, the patent, design, or copyright, you have to decide. And the collaborations, the contracts, if you are working with the outsourcing and the third parties. We call good practice to record research and creative work with notebooks or work journals. It's very critical because, as I already mentioned, to collect the data to support the patent applications, to determine the inventorship and ownership. And if you are a pharmaceutical company or if your inventions are pharmaceutical, it's very important for the regulatory purposes to have the data and all the experimentals, and for the contractual obligations, and to determine the know-how, also for license deals, or maybe you should decide to spin out a company, so it's important. And we all know what is the invention disclosure form. I just mentioned the last one. It's also important for the attorneys to have the novelty and inventive step. In my case, it's very important. It's very easy to determine the novelty from the researchers, but always to inventive step, sometimes they're not aware of it too. So it's make your life very easy if you use it. And if you are working with R&D people, they always want to publish their invention before patenting it because they think it's very important to have prestige. So you should give advice on timing of your publication. Of course, it not be before the application, but if there's no timing, at least you can control what they will publish. Does it contain information relevant to a patent application, or you may you should keep some know-how and with all certain information. Also, you should take precautions regarding the disclosure of the confidential information and materials. You can use non-disclosure agreement and the MTA, material transfer agreement. Again, I will tell you what it is at the end of the case of my slide. And if you look briefly to collaborations, you should all know definitions of the IP used, created in the project, how you will manage it, ownership access rights and improvements to IP, who will file and prosecute the patents, this is important, and sharing the costs, risks and returns and term of publications. Now in the second part, I would like to give the strategy of IP and give the objectives and tactics briefly. When developing and protecting your IP, you have to decide to monopolize if you want to monopolize the invention. If yes, you have 3 points. You can, without doing the patent application, you can publish it to ensure wide access that nobody also can use it, but, nobody can have the protection, but everyone can use it. Or you can decide to protect the patent with IP forms to have the monopoly only for you, only for the owner. And you can keep it as secret, as you wish. And in second part, managing the IP filing strategy, you have to maintain application for a limited duration and you have to decide in which territories you have to go, you have to have the protection. And enhancing the technology, of course you want to develop the technologies and create a portfolio related to other IP forms. And when creating the competitive advantage by optimizing and using IP, again, you have some strategic objectives. As we already talked about the creating monopoly, you have to also be aware of the IP landscape and the freedom to operate. You have to monitor the competitors and you will be careful about the infringers and of course in your field you should not infringe too. So you can have defensive patents too, creating defensive patents for the managing competitors. And you may want to cross-licensing deals with trading the IP. And this part, securing finance, also if you are working with universities, it's important for them to build IP portfolio to attract investment because they need to work with the companies. And monetizing the IP portfolio, you may want out-licensing or sale of it or spin-out companies. And again, it's important to have collaborations in licensing acquisitions. Then at last, we came to commercializing of the IP, which is very important for the companies because after all, you need money. And for evaluating it, there is 3 main points, the legal status, technology, and market conditions. You have to evaluate legal status and some questions arise, like patent status, ownership, and enforcement means. And when evaluating of technology, the questions could be uniqueness, the stability, and reproducibility, and how easy it is to identify infringing products. It's very important. And when evaluating the market conditions, the questions could be, what are the commercial opportunities? What are marketing options? Is freedom to operate easily achievable? How big are the margins, turnovers, and market growth rates? And after all, you'll evaluate all them, and we will have the IP evaluation process. As you all aware of it, there are 3 milestones for the prosecution of patent application. The first milestone is the prior to filing. It's the start of the prior to year, and after the evaluation, there is a second milestone. It's the internationalization part. It could be a PCT or directly EP route. And the third milestone, after the PCT route, you have the 30 to 31 months for the nationalization. I give this because in IT or IT technology, it's more, everything is changing more fastly. So maybe you can want your application to publish and changing market, but if you are in pharmaceutical, it's very important to stay 30 months, especially when you start your protect your patent application, and you may not decide in which territories to go after the second milestone. So you may continue, you may want to nationalize for 30 months. It's easy for us. And let's have a shortened presentation, the IP management. Is there a pointer in? Sorry. Which one is the... Okay. Thank you. This is better now. And we start from the R&D in licensing. There are internal and external exploitation. The R&D and in licensing, then we have to invention disclosure. We have to have disclosure forms. It comes, and then you evaluate it if you want to have patent protection or IPR protection or not. Usually yes. And then the exploitation part, the business case, important, license agreements. Maybe you may want to sell assignments and the spin out, because you may sometimes have the finance is very important. You may want to spin out the company. It's more easy. And in this part, the licensing is more important, and I would like to give some benefits of it briefly, and then I would like to talk about the licensee and licensor part. What are the differences or the similarities? We all know that intellectual property rights prevent others from using our inventions. So you cannot enter the area that you are protecting. And you need contractual agreements, and this allows others to use your inventions now and creations if you want, but you decide with the specific terms and conditions which rights they can use in what extent. And the requirements for a legal contract, of course you need a contract, and mutual exchange of a bargain and two sides, and you have to consider about the payment, the license fee and the royalties, and exchanged for something of the value like IP. And you set the terms and conditions, as I said before. The benefits of licensing, licensor part and licensee. In licensor part, you create new source of revenues, and you access new territories and markets, and influence market acceptance for technology and products, create production and supply partnerships. In licensee part, you gain access to new technologies, turnkey products and processes and new markets. It may be expensive, but it's more easy because you reduce or avoid R&D costs and associated risks, and provide competitive advantage, and you have the IPR protection too. At last, increase asset value of business, and which will increase the value of your company too. And maybe you're all aware of, because it's an old case in pharmaceutical, actually it's in the biotech case, IIPLA and between IIPLA and Aventis. Aventis is one of the pharmaceutical companies. Shortly background, there are scientists at the Weizmann Institute, and they conduct a research. Later on it will be the IIPLA, we call it. And they are using antibodies and scares. Don't be afraid, I'm not going details of the biotech, but just to give a brief, it's about the cancer and monoclonal antibodies, how the treatment of specific cancer. And the professor named Sela, a former colleague, provides material for using the experiments. Professor Schlesinger, they have a brief talk, and they tell their experiment, their research, and he said that he can help with providing the monoclonal antibodies. Then, promising results are obtained. Schella's group prepared a paper for publication, as all researchers do, and the patent application is filed, but from Professor Schlesinger, and patent is licensed to a biopharma company, which is Aventis. And ownership of the patent is disputed. The litigation starts because when Schella's group, the company IIPLA, aware of the patent application, it's too late that they are not the inventorship, they are not the inventors, and then litigation. So let's have a look at very shortly the experiment. There is a drug, there is the monoclonal antibody, there is a conjugation with MAB and drug, and there is a mixture of MAB and drug. If you are in this field, you know that you think that before looking at the results, the experiment C should show significant activity. So they all think that it will be the most powerful. After the experiments, they realized that experiment D has the significant inhibition, the surprising effect as we all call. Then, after all, it becomes more valuable, and there is the publication from the Shell's part, and there is the patent application arise. As you can imagine, Shell didn't consider filing a patent application, and MAB owned by Schlessinger's employer, Rohrer Biotechnology, and Shell's group prepares publication. They also show it to Schlesinger. He is also named as author of the contribution. There's another wrong thing. Also, paper published in December 1988. And patent application prepared, unbeknown to Yeda. There is two claims important. One, antibodies, it's the MAB only, and the mixture, the invention D, and we can say invention, the experiment B and D. And inventors named are all Rohrer employees, of course. And US patent application filed in September 1988, only few months before the publication. Then the license, then to begin everything. And in 1994, Rohrer grants exclusive license to IIPLA. And IIPLA invests USD 190 million in developing cancer therapy. 1999, Aventis acquires Rohrer and patent after series of mergers. The name of the drug is Erbutix, and it receives 2 FDA approval. One is in 2004, colorectal cancer. The other is 2006, head and neck cancer. Very, very important things. And the sales of Erbitux in order to USD 400 million per year. It's very good invention, I can say. And when we go to the patent dispute, how it will, it's granted and published in 2001, and US patent limited to claims. It's interesting in here. In US, it's only limited to the mixture, the experiment D, but other territories, it's granted to MAB only and to mixture. Here, there is two things for the inventorship, because Shell's group, Yeda, especially only for this, we will see for the inventorship. 2002, Shell became aware of patent and raises concerns. Then Yeda entered the discussion, but no resolution. They wanted only the joint ownership. It's also interesting. They are still very thinking not broaden. They only want joint ownership. They refuse it, and after all, they are very regretfully because they lose their ownership too. And Yeda starts court proceedings, and litigation part and the court decision. So Yeda's case is that experiments and inventive concepts originated from Shell, and all the specification and draft publications came from that. And defendant's case that no, the map we provide the map for the experiments. We had all the projects. And the court decision, of course, they give the inventorship of the patent corrected to the Yeda becomes owner of the patent. At the beginning, if they share the if they accept the joint ownership, they won't lose lots of things. Out of the court settlement reached 2007, Yeda owns US patents, and they jointly own patents in other territories. This is also interesting. And there are the royalty fees paid very in the increasing amount. Aventis and IIPLA pay 60 million USD, to Yeda. And IIPLA pays Yeda and Aventis royalty sales outside the US. So what can be done in order to, as I said you, at the beginning, when Yeda be aware, they can give accept the joint ownership because they lose everything in the US especially. So the lessons learned is very easy and brief. They should have used the non-disclosure agreement, and they should have used the material transfer agreement because they cannot prove that they give the monoclonal antibody to them. There is no lab notebooks or things for the Professor Schlesinger too. So they have the lab notebooks the Shell's group have, and they prove that they they are the inventors. And they can use invention disclosure form, then there will be no fight against between who is the inventorship, who is the ownership. As I said, the documentary is very important. And thank you. I hope I keep my timing in. I'm trying to be fast.